Hello students, welcome to EPG Pathshala. I am Dr. Rupak Chakravarti, faculty member, Department of Library and Information Science, Punjab University, Chandigarh. Today I am going to talk about right to information, its concept, scope and features. It is of the lesson Media and Information Literacy. As you know that asking questions have been a human tendency. We have been asking questions. RTI is all about asking questions, getting answers as a right. The objectives of this lesson are to develop conceptual background of right to information, to discuss the importance and need of RTI in the society, to envisage the scope, limitations and exclusions of RTI, to explain the role of public authorities and Assistant Public Information Officer, to present a brief account of CIC, to explain the important clause sections of RTI Act, to explain the procedure for RTI application, which is very important. Regardless of the constitutional provisions, the system of governance in India has traditionally been opaque, with the state retaining the Colonial Official Secrets Act (OSA) and continuing to operate in secrecy at the administrative level. The Central Civil Service Conduct Rules 1964 also strengthened the OSA by prohibiting government servants from communicating any official document to anyone without authorization. The major factor which influence the free flow of information are bureaucratic culture, illiteracy and absence of effective communication tools. No doubt there is need for administrative secrecy in certain cases. No one wants classified documents concerning national defense and foreign policy to be made public till after the usual period is over. But at the same time, every citizen has a right to know how the government is functioning. Right to information empowers every citizen to seek information from the government, inspect any government documents and seek certified photocopies of the same. Some laws on right to information also empower citizens to officially inspect any government work or to take sample of material used in any work. In this slide, we will discuss the meaning of information in context to right to information. We have already understood and studied the DIKW model, which says that data, information, knowledge and wisdom. But here, the information means any material in any form, including records, documents, memos, emails, opinions, advices, press releases, circulars, orders, logbooks, contracts, reports, papers, samples, models, data material, which can be held in any electronic form, and information relating to any private body, which can be accessed by a public authority under any other law for the time being in force. In the context of right to information, it is very essential to know what does a record means. Basically, a record includes any document, manuscript and file. It can be in the form of microfilm, microfiche and facsimile copy or fax copy of a document. It includes any reproduction of image or images embodied in such microfilm, whether enlarged or not, and a record may also include any other material produced by a computer or any other device. Right to information. Right to information, or popularly known as RTI, stands for Right to Information and has been given the status of a fundamental right under Article 19(1) of the Constitution. Article 19(1) says that every citizen has freedom of speech and expression. As early as in 1976, the Honorable Supreme Court said in the case of Rajnarayan versus State of UP that people cannot speak or express themselves unless they know. Therefore, right to information is embedded in Article 19 and is a fundamental right. In the same case, Supreme Court further said that India is a democracy. People are the masters. Therefore, the masters or the people have a right to know how the governments mean to serve them are functioning. Further, every citizen pays taxes. The citizens therefore have a right to know how their money was being spent. These three principles were laid down by the right of the people of India. RTI. Dear students, let us now understand the basic concept of right to information, that is RTI. RTI as an act came into force on 12th October 2005. The objective of the act was revolutionary when seen in the Indian context, as it opened all official departments across the country to public scrutiny. RTI mandates timely response to citizen requests for government information. The RTI Act 2005 provides effective access to information for the citizens of India, which is under the control of the public authorities. It promotes transparency and accountability in the working of every public authority. It extends to the whole of India except the state of Jammu and Kashmir. In order to ensure greater and more effective access to information, it was decided to repeal the Freedom of Information Act 2002 and enact another law for providing an effective framework. To achieve this object, the Right to Information Bill was introduced in the Parliament and was passed by the Lok Sabha on 11th of May 2005 and by the Rajya Sabha on 12th of May 2005. It received the assent on 15th June 2005 and it comes into force on the 12th October 2005, that is the 120th day of its enactment on 15th June 2005. It came on the Statute Book of the Right to Information Act 2005. The Act extends to the whole of India except the state of Jammu and Kashmir. The Right to Information Act empowers citizens. In this diagram, dear students, it is shown that how RTI can empower citizens and make them enabler. It has affecting the citizens' right in three ways. First, demand responsibility from public servants, bring to light issues of poor governance and bureaucratic apathy, and thirdly, hold public servants accountable for their actions or lack of it. It is the third aspect, that is holding the public servants accountable, that it can prevent corruption and red tapeism. Dear students, it is very important for the common man and citizens and for you and me, for us, to understand what is the procedure for requesting information. Unless and until we know the procedure to file an RTI and retrieve the information we want, it is of no use. Therefore, we are going to discuss the application procedure for requesting information. Mode. The RTI can be claimed writing or through electronic means, and the format of application is, there is no prescribed format of application for seeking information. The application can be made on plain paper. The applications should, however, have the name and complete postal address of the applicant. As far as the language of the RTI application is concerned, it allows that English or Hindi or in the official language of the area, which means that language is not a barrier in asking for RTI. It is also to be noted that reason for seeking information under RTI is not mandatory and it is not to be given. However, if a person who wants to retrieve information through RTI finds it difficult, there is a provision of assistance available to the applicant for filing RTI application. The assistance means if a person is unable to make a request in writing, the Public Information Officer or PIO should render him reasonable assistance. When a decision is taken to give access to a sensorily disabled person to any document, the PIO shall provide such assistance to the person as may be appropriate for inspection. As far as the fees is concerned, the fees should always be reasonable, and it is always required by the organization to prescribe the fee. The fees may be 10 rupees also. If further fees are required, then the same must be intimated in writing with accurate calculation details of how the figure was arrived. Not applicable for citizens below poverty line. That means there is no RTI fees for the BPL category. Application must be provided information fee of cost if the PIO fails to comply with the prescribed time limit. As regarding the time limit of RTI, suppose a person files an RTI, from how much time the person shall wait to receive the information? Normally, the duration is of 30 days from the date of application. But if the case is of life and liberty, the matters which involve life and liberty, the time limit for the Public Information Officer or PIO to provide information is 48 hours. 5 days shall be added to the above response time in case the application for information is given to Assistant Public Information Officer, that is APIO. If the interests of a third party are involved, then time limit will be 40 days maximum period plus time given to the party to make representation. Failure to provide information within the specified time period is deemed refusal. As far as ground for rejection is concerned, it is here mentioned that if it is covered by exemption from disclosure, only then it can be rejected, or if it infringes copyright of any person other than the state, then these can serve as the ground for rejection. Dear students, let us now discuss what are the rights which are offered under the right to information, because if we are aware of our right, then we can ask for it. RTI includes the right to inspect works, inspect documents and inspect records. Under RTI, it is allowed to take notes, extracts or certified copies of documents and records. Here, the permission is also given to take certified samples of material. RTI also includes the right to obtain information in form of printouts or discs. Dear students, let us now discuss the main objectives of RTI Act. The main objectives of RTI Act include to provide a legal framework of citizens' democratic right to access to information under the control of public authorities. The aim is to promote transparency, which shall ensure accountability, harmonize conflicting interests and priorities in operations of government and use of resources. It includes realization of human rights and practice of revelation of information to preserve democratic ideals. The objectives also include to promote accountability in the functioning of every public authority, there be reduced corruption. It also includes better record keeping and decision making. Dear students, we are talking of RTI, but we also must remember that there are certain traditional practices of verbal communication. Let me tell you that government offices have been providing information to people on the basis of their oral request in the past. With the coming of RTI, there is no such mandate that the government will stop doing that. No, there is no need to discontinue the conventional and informal practices of giving information upon oral or verbal request. The RTI Act does not put an end to such practices. If information can be given without delay upon oral request, it is better to give such information to the requester rather than require him or her to put in a formal application. This will also help in reducing paperwork of the public authority in addition to saving time. Dear students, let us discuss a very crucial aspect which is called voluntary disclosure. Why providing information only after it has been asked? Is there any other way out? Yes. There is a procedure of voluntary disclosure which will minimize the workload, reducing the workload. If public authorities disclose certain information which is important to the public voluntarily at every level of operation systematically, it will reduce the workload of officials and public authorities with regard to the requirement of providing information on request. This is because the information which is regularly needed by the public can be accessed by them without the need of going through a process of making specific request and then waiting for the information to be received. Dear students, it becomes very essential to know who are the public authorities to whom we may file the RTI application. The RTI Act defines a public authority as any authority or body or institution of self-government established or constituted by or under the Constitution, by an other law made by the Parliament, by any other law made by the state legislature, by notification issued or order made by the appropriate government, and includes any body owned, controlled, or substantially financed. Non-government organizations are also included, which are substantially financed directly or indirectly by the appropriate government. Let us discuss what are the obligations of public authorities. Public authorities cannot deny, cannot refuse the RTI, and they have certain duties to be performed. These obligations are: it shall publish within 120 days of the enactment the particulars of its organization, its functions and duties. It shall publish the powers and duties of its officers and employees. It should publish the procedure followed in its decision-making process, including channels of supervision and accountability. It should publish the norms set by it for the discharge of its functions. Students, as you know that it is almost mandatory for the public authority to provide information under the RTI Act. Now the question is, what are the obligations on the part of this public authority? The public authority has to do certain tasks, and those are the rules, regulations, instructions, manuals and records used by its employees for discharging its functions, that has to be provided under RTI. A statement of the categories of the documents held by it or under its control. The particulars of any arrangement that exists for consultation with or representation by the member of the public in relation to the formulation of policy or implementation thereof. A statement of the boards, councils, committees and other bodies consisting of two or more persons constituted by it. Additionally, information as to whether the meetings of these are open to the public or the minutes of such meetings are accessible to the public. A directory of all its officers and employees, the monthly remuneration received by each of its officers and employees, including the system of compensation as provided in its regulations, the budget allocated to each of its agency, indicating the particulars of all plans, proposed expenditures and reports on disbursements made, the manner of execution of subsidy programs, including the amount allocated and the details and beneficiaries of such programs, particulars of recipients of concessions, permits or authorizations granted by it, details of the information available to or held by it reduced in an electronic form, the particulars of facilities available to citizens for obtaining information, including the working hours of a library or reading room if maintained for public use, the names, designations, and other particulars of the public information officers. Students, let us now discuss who are the public information officers. We may file an RTI application to any public information officer. Let us know who they are. Public information officers or PIOs are officers designated by the public authorities in all administrative units or offices under it to provide information to the citizens requesting for information under the Act. Every public authority shall have to appoint a public information officer irrespective of the size of its office or administrative unit, which means that any public authority cannot deviate from appointing a public information officer just by saying that the office is of a small size. This includes panchayats and municipalities or any local authorities. Public information officers, here it is pertinent to note that assistant public information officers are not an assistant to the public information officers. They may work independently. Let us now discuss what are the duties of a public information officer. Public information officer shall deal with requests from persons seeking information, and where the request cannot be made in writing, to render reasonable assistance to the person to reduce the same in writing. If the information requested for is held by or its subject matter is closely connected with the function of another public authority, the public information officer shall transfer within 5 days the request to the other public authority and inform the applicant immediately about this transfer of request. The public information officer may seek the assistance of any other officer for the purpose of discharge of his or her duties. The public information officer, on receipt of a request under RTI, shall as expeditiously as possible and in any case within 30 days of the receipt of the request, either provide the information on payment of such fee as may be prescribed, or reject the request for any of the reasons specified under Section 8 or Section 9 of the RTI Act. In continuation of the duties of public information officer, it is very essential to note that where the information requested for concerns the life or liberty of a person, this same shall be provided within 48 hours of the receipt of the request. If the public information officer fails to give decision on the request within the period specified, he shall be deemed to have refused the request. Where a request has been rejected or refused, the public information officer shall communicate to the requester three things, which include the reason for such rejection, the period within which an appeal against such rejection may be preferred, and thirdly, the particulars of the appellate authority to whom the next appeal can be made. The public information officer shall also provide information in the form in which it is sought, unless it would disproportionately divert the resources of the public authority or would be detrimental to the safety or preservation of the record in question. Dear students, let's discuss the very important concept of exemptions. You cannot file RTI and expect all information, which means that all types, all nature of informations are not covered under RTI. The RTI Act has provision of certain exemptions for disclosure, which includes information disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific or economic interests of the state, relation with foreign state, or lead to incitement of an office are to be exempted. Information which has been expressly forbidden to be published by any court of law or tribunal, or the disclosure of which may constitute contempt of the court, are to be exempted. Information the disclosure of which would cause a breach of privilege of Parliament or the state legislature are also to be exempted. Other exemptions include information regarding commercial confidence, trade secrets or intellectual property, the disclosure of which would harm the competitive position of a third party, unless the competent authority is satisfied that larger public interest warrants the disclosure of such information, also to be exempted from disclosure under the RTI Act. Other exemptions from disclosure under the RTI Act include information available to a person in his fiduciary relationship, unless the competent authority is satisfied that the larger public interest warrants the disclosure of such information. Information received in confidence from foreign government is also considered under exemption from the disclosure. Information the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes are also exempted from the disclosure. Continuing with the exemptions of disclosure, we may say that information which should impede the process of investigation or apprehension or prosecution of the offender are to be exempted. Cabinet papers, including records of deliberations of the Council of Ministers, Secretaries, and other officers, are also exempted. Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, cannot be asked under RTI as they are exempted. Notwithstanding any of the exemptions listed and discussed ago, a public authority may allow access to information if public interest in disclosure outweighs the harm of the protected interests. Students, let us now discuss the status of Public Sector Unit or PSU in the context of right to information. The RTI Act says that the public sector units that is PSU fall within the category of public authorities, even if the law constituting a PSU does not allow disclosure of certain categories of information. The RTI Act 2005 overrides any such law in existence. Hence, the designated public information officer for the organization under question has to provide information. However, if an applicant seeks information that includes commercial confidence, trade secrets, or intellectual property rights that are IPRs, etc., the disclosure of which will affect the competitive position of that public sector unit, such information may not be given unless there is a larger public interest involved. Questions have often been asked and discussed regarding the annual confidential reports or ACRs which are kept in various offices. According to the RTI, as per the Central Information Commission, the assessment reports by the superior officers are personal and confidential information, therefore exempted under Section 81J of the RTI Act. The Central Information Commission or the CIC maintains the annual performance appraisal reports cannot be shared as they are confidential in nature. Manuals. In the RTI Act, there are 17 categories of information that a public authority is required to prepare and disseminate proactively through handbooks, notice boards, print, and electronic media. If the organization is able to disclose all such information falling under the 17 categories, it will amount to the voluntary disclosure of information and will be in the right spirit of the right to information. Dear students, what happens if the public authority or the public information officer or the assistant public information officer rejects or refuses your RTI application? Dear students, let me tell you that there is a provision of penalty in the RTI Act. Can officials be punished if they do not comply with the law? Yes. Public officials who deliberately delay or obstruct an application of information or who deliberately provide incorrect or misleading information can be punished under the RTI laws. Penalty. The Central Act allows for the imposition of penalties, most notably where a PIO has, without any reasonable cause, done the following things: refused to receive an application, not furnished information within time limits, malafidly denied the request, knowingly given incorrect, incomplete, or misleading information, destroyed information subject to a request, or obstructed the process. All these types of acts constitute the violation of the RTI Act and call for penalty. Now let us discuss what are the scope and limitations on information sought. There are certain limitations. The Act does not permit rejection of an application simply because it relates to a large number of documents. One cannot deny that. An applicant can ask for 20 to 30 different kind of information in the same application and cannot be asked to apply afresh. So different application for different kind of information, no, that is not required. If the information published under section 4 B of the Act is comprehensive and proper information systems are maintained to enable such publication. Even if an applicant requests for many pieces of information, the same can be provided to the applicant without much difficulty. Appropriate record management system need also be instituted. A PIO can request the applicant to visit his or her office personally on a notified date and time to inspect the required documents or files. Under section 9, information shall be provided in the form in which it is sought unless it would disproportionately divert the resources of the public authority. The PIO has to determine and justify what constitutes the misappropriation or diversion of resources. If the same kind of information is sought by more than one person, it should be made available to all such requesters. You cannot say that this information has already been given to some person, therefore no more such queries can be made. No. However, it is advisable that such records be digitized as far as possible and uploaded on the internet to facilitate easy access. If the information requested by a citizen has already been proactively disclosed, a PIO cannot refuse to accept the request, and it should be provided to a citizen on request in the available formats upon payment of the requisite fees or charges at rates prescribed by the government. Dear students, let us now discuss a very interesting phenomenon which has been observed under the RTI, what we are facing right now. The concept is of misuse and abuse of right to information, myths and realities. It is inaccurate to assume that some elements may misuse RTI and use the information to blackmail or threaten officers. On the contrary, the Act actually prevents blackmail to honest and sincere officers, as it requires making as much information as possible available with the public authorities in the public domain. An honest and sincere officer need not fear blackmail at all. The strict adherence to the law would facilitate smooth functioning of such officers, as they will be protected by the law. I must share a very valuable information with you. You may find RTI a very effective and powerful act, and rightly said, because we are heading towards the information society where we want the free flow of information and sharing of information. In this context, it is very important for all the citizens of India, citizens of any country, to gain and get awareness regarding the right to information. For you, there is a very good news. There is availability of online certificate course on right to information, which is called RTIOCC. The Department of Personnel and Training, Ministry of Personnel, Public Grievances and Pensions, Government of India has launched an online certificate course on right to information for all. This online certificate course on RTI is launched in association with the Center for Good Governance, Hyderabad. It also provides a RTI portal to the citizens for quick search of information on the details of first appellate authorities, public information officers, etc., among others. Besides, access to RTI related information disclosures published on the web by various public authorities under the Government of India as well as the state governments. Users can also take up RTI quiz online to test their knowledge on RTI. This online certificate course on RTI are of two types. The first course is the 7-day online course in English, which is introductory in nature. If you want to take up a course in much detail, then there is option of 15-day online certificate course, which is again in English, This course is extensive with the practical orientation whereby candidates will have to apply an RTI application during the course period. The 15-day course period will be based on the principle of learning while doing. Therefore, it is suggested and advised and requested that those who take the 7-day course must follow it up with the 15-day course for in-depth understanding and utility of the RTI Act. Students, let us now summarize and conclude the topic of right to information. We have all understood that right to information paves the way for the information society wherein people enjoy information democracy. RTI strives for right information to the right person at right time in the right spirit, at right cost and in right format, which adherence to minimum exceptions, duty to inform, accountability, provisions for setting up systems to maintain records and store information for easy retrieval, reasonable fee structure to obtain information, time limits for providing information. RTI can lead to a corruption-free society where the government, whether it be local, regional or national, are more accountable and transparent with protection of privacy and protection of whistleblowers. Whistleblowers mean an informant who exposes wrongdoings within an organization in the hope of stopping it. However, the wider acceptance to RTI will come through wider publicity and training at different levels. The Right to Information Act is one of the biggest achievements of the Indian democracy. We can also say that the Act, which is one of the most powerful legislations of its kind in the world, is also to the closest of citizens' heart. It has empowered the citizens in an unprecedented manner to participate in nation building by promoting transparency, accountability in the working of every public authority. Thank you, students.